All right, folks, welcome into It's the Law. Attorney Jay Davis is here from James W. Davis and Associates for our weekly It's the Law segment. Jay, the difference, we see it all the time, in crime reports, assault cases, battery cases. The basic question is, what's the difference?
What's the difference? Yeah, a lot of times we get assault and battery, and we're like, well, what does that mean?
Right.
Yeah. Well, generally, assault is by legal definition, assault generally means that you don't actually hit somebody, you don't actually touch somebody. You do a threatening movement, you go at them, you do something that makes them fear. They're in fear of their safety or their general safety. And that Georgia sort of expounded that sort of definition, and it actually includes some minor touching. If you touch somebody but you don't leave a mark, you sort of grab them, your intent was to do something, put them in fear, or to do something forceful, but maybe it wasn't forceful, maybe you didn't leave a bruise, maybe you can't look at somebody and tell that that's done, that's still probably classified as assault. Used to, the fine line used to be whether or not they were touched. That's no longer the fine line before.
The times I see battery is, maybe a fight broke out in a parking lot, the late night scuffle where somebody gets hit in the face. That sort of qualifies as battery?
Well, battery is going to be somebody who was hit to where you actually see some sort of damage. You get a black eye, you get a bruise, you have something that they leave where you have a physical mark on your skin. A lot of people think that you're going to get, charged with battery if you're fighting in a back parking lot or something like that. And some people think that if you're fighting and you both want to, then it's not a crime. Both of those are actually wrong. There's something called an affray. It's A-F-F-R-A-Y.
An affray.
Affray is the actual charge for that, where you're two mutual combat, two people willing to engage in a fight, two people willing to go forward. That's still a crime. You don't have permission
you can't do that.
just because you both agree to it to go out there and beat each other up. That's still not a crime.
So
that still is a crime.
Yeah. So I'm sure it varies, the severity of the case, but generally speaking, a simple assault and a simple battery, do they carry the same weight in terms of punishment?
Generally speaking, that's true. That they're both misdemeanors, so misdemeanor carries up to a year. Both of them can be aggravated, can have some other extenuating circumstances that aggravate them into a felony. So if it's an aggravated assault, aggravated battery, that's going to be into a felony range. You also have something at the misdemeanor level that can still be an aggravated, not in the sense of an aggravated assault or a new crime, but if somebody does that on a pregnant woman, for example, that can be a higher misdemeanor crime. It can carry more time, it can carry more penalty, but it's still going to max out at a year. Generally, misdemeanors, for the most part, when they're this type of thing, can be served on probation. If you get into the higher misdemeanor levels, sometimes some portion of that sentence or all of that sentence may have to be served. But a lot of people miss that on a fray. I've had somebody where I've had my client accused of an affray, arrested for an affray, and I'm like, what about the other person? Well, we let them go. I'm like, oh no. That affray by definition requires two people. If you don't have another one charged, you're not going to let mine hang out there by themselves.
You get charged, that's your guy. If there's a question that you want to answer or a topic for Jay to discuss, email itsthelaw@41nbc.com. Appreciate you coming on, Jay.